Welcome back to the 394th Judicial District Court. We are holding court today remotely in Brewster County, Texas, in cause number FMB 23220, in the matter of the marriage of Lee and Jackson Wilburn, and in the interest of their children. We are set today for final hearing. I will entertain announcements of counsel at this time.
Good morning, Your Honor. Julie Balovich for petitioner Lee Wilburn. We're ready.
Morning, Your Honor. Stephen Patanti for respondent, appearing on a limited scope basis just for today's hearing, replacing or here for Andrew Atkins, who had a calendar conflict, but I've been familiarized with the case, so I understand what the issues are. Thank you.
All right. Thank you very much. Well, I have noted that there are two witnesses in the waiting room. I'm going to admit them, swear them in, place them under the rule, put them back in the waiting room. I will tell you at the time, but I will remind you now that part of my standing order is that the order is also to the lawyers to ensure that their witnesses do not violate the rule. So if you learn that a witness is going to be called who I've not sworn in, or if you come to find out a witness is watching, you are required as officers of the court and under the court's standing order to inform me of this so that I can take appropriate action. I'm going to admit the witnesses at this time. Okay, I do have a proposed final decree of divorce that has hit my desk. It appears to be digitally signed by both counsel and both parties and declares that it is the result of a binding mediation process. So is that true or no?
No, Your Honor. We did engage in mediation, but we did not execute a mediated settlement agreement. We were able, however, to build on that to do a settlement on all issues except for one issue that we will ask the court to consider evidence and make a ruling on today.
All right. So the one issue I saw when I reviewed the decree, there's a blank.
Yes, sir.
A single blank on page 20 of 24. Is
Yes,
that
sir.
the one issue?
Yes, sir.
All right. I need the parties to activate their cameras. Remember, if you're in the virtual courtroom, it's just like being in the well of the court. If your camera's off, it's like hiding under the desk. So let's get our cameras turned on so I can see everyone who's here. So do you intend to each call your clients to testify?
Yes, Your Honor.
All right, let me have the two of you raise your right hands, hold them up where I can see them. Each of you solemnly swear the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth. Ma'am?
Yes, Your Honor.
Sir? Did you answer, Mr. Wilburn?
I do.
All right, thank you. Lower your hands. All right, do you wish to make an opening statement or wait, Ms. Balovich?
Just to give the court some guidance of just to make this simpler, what I plan to do, Your Honor, is go through a prove-up of the decree up until we're getting to the issue that we need evidence on, and then I'll ask my client for a little more expansive testimony on that issue.
All right, that'll be fine. I'm not sure. Hold on. He has the right to address me as well. I want to make sure I'm pronouncing your name correctly. How do I pronounce your name, sir?
Patanti.
Patanti. Mr. Patanti, do you have anything you wish to inform me for opening purposes?
For opening purposes, like I said, like counsel has said, the issue is a sole issue. My client's issue with the exclusivity of using the app close as the sole method of communication has to do with the fact if it's an emergency, if it's something that he needs to communicate with her on, and if it's also something that requires a conversation, such as conferring on things like medical, dental, psychiatric, psychological health reasons, health, safety, and welfare reasons. The issue is the app being a sole method of communication, we believe is unworkable in this situation.
All right.
And that's what he'll testify to.
All right. Thank you very much. Ms. Balovich, call your first witness.
I call Lee Wilburn.
All right, Ms. Wilburn, you are under oath. It is your turn to testify. Would you tell me your full legal name, please?
Lee Victoria Wilburn.
Your witness, Ms. Balovich.
Your Honor, would it be possible for me to share my screen so I can go through the decree with her?
One moment.
How does that work?
Perfect.
All right. Ms. Wilborn, you were married to Jackson C. Wilborn on November 18th, 1994,
Yes.
and you separated from him on May 14th, 2023.
Yes.
You filed your petition for divorce on June 13th, 2023.
Yes.
And before you filed the petition for divorce, you had been a resident of Brewster County for at least 90 days and a resident of Texas for at least 6 months.
Yes.
Has your marriage become insupportable due to a conflict of personalities that has destroyed the marriage relationship?
Yes.
Is there any chance of reconciliation?
No.
You and Mr. Wilborn have 9 children together, correct?
Yes.
And 5 of those children are currently under the age of 18.
Yes.
And those children are Wyatt, age 5, Darby, age 10, Magdalena, age 12, Elizabeth, age 14, and Sarah, age 16.
Yes.
And you have no other children expected, correct?
Correct.
Have you and Jackson reached an agreement regarding conservatorship and possession of the children?
Yes.
And is that agreement reflected in the final decree of divorce that has been submitted to the court and which bears yours and Mr. Wilborn's signature?
Yes.
And I'm going to go over a summary of that agreement. It provides that you and Mr. Wilborn are appointed parent joint managing conservators of the children, correct?
Yes.
With the exception that you share all rights and duties except the rights and duties that are normally appointed to a sole managing conservator are going to be granted exclusively to you. Is that right?
Yes.
The one exception is that y'all have agreed that the 2 of you would have to agree regarding consent to marriage or enlistment of the armed forces.
Correct.
The possession order that y'all have agreed to is not the standard possession order. You've asked that it be modified, and it's more restrictive than a normal standard possession order. Is that right?
Yes.
Because the 2 of you are currently over 100 miles away, and you've agreed, regardless of the distance between you, he will get the first and third weekends of the month, and 1 week of spring break, and if there's fall break, 1 week of fall break, and then otherwise a period of about 4 weeks during the summer. Is that right?
Yes.
You've also had an agreement that you will exchange the children in Van Horn at the McDonald's, and that if the location of either of you change and you're unable to agree to a new exchange, the exchange would occur at a McDonald's that is nearest the halfway point between the parties using the shortest mileage driving distance.
Correct.
And this possession also only applies to the 3 youngest children. It does not apply to Sarah, and it does not apply to Elizabeth. Is that right?
Yes.
Okay. Now, your child support amount has been currently set at $2,000 per month with the step downs as each of the children achieve the age of majority or another event occurs.
Yes.
And you've also agreed that Mr. Wilborn owes an arrearage in the amount of $2,300 as of December 31st. Any amounts he's paid as of after December 31st would be credited toward that judgment, correct?
Correct.
And he has agreed to pay $250 per month until that is paid with the statutory interest rate. Correct?
Yes.
Okay. Mr. Wilborn has also agreed to continue to provide medical insurance for the children, and that has been taken into account as part of this child support amount. Correct?
Yes. Correct.
And that each of you will split any medical debts that are otherwise not provided for by insurance.
Correct.
Turning to the division of the property, do you agree that those orders, which are a compromise for both of you, are in the best interest of the children?
Yes.
Okay. Turning to the division of the property, actually, before I get to that, there were some miscellaneous expenses y'all have agreed to split. Each of you are going to cover 50% of the cost of automobile insurance for the children as they get old enough to drive.
Yes.
Mr. Wilborn has agreed to pay the cost of mobile phone service for Sarah, Elizabeth, and Magdalena, and you will pay the cost of mobile phone service for Darby and Wyatt.
Yes.
Now turning to the division of the property. You and Mr. Wilborn held a couple of family businesses in Alpine, correct?
Correct.
And the agreement is going to be that you are awarded basically everything in your possession, with the exception of a few items that are still in Alpine that you will come collect. You will be awarded all sums of accounts and accounts in your name, the IRA in your name, the 2020 Ford Explorer in your name. And that he is going to be awarded all of the rest of the community property, which includes all property associated with those businesses.
Correct.
He's also going to be awarded the 2 real property and the property and improvement.
Yes.
And he's also, as part of the division of the estate, and he's also going to have all of the vehicles that are currently at that property.
Yes.
Your daughter, Sarah, drives a 2006 Hyundai motor vehicle. He will be awarded that to be held in trust for her benefit until she turns 18, at which point it's turned over to her.
Yes.
You're going to be responsible for the debt on the motor vehicle that is awarded to you, and any other debts that you've incurred, and 50% of the medical debt that's currently outstanding for Wyatt. Is that right?
Yes.
And Mr. Wilborn is going to be awarded all debts associated with the business, the real property, vehicles, the personal property that he is getting awarded in this decree. He has specifically agreed to assume the loan that is jointly in your name on the homestead, and to either refinance, sell, or otherwise have your name removed from the financing by December 31st, 2026. Correct?
Yes.
Okay. And as a judgment to equalize the division of property, he's agreed to pay $12,600 to you in monthly installments of $300 a month beginning January 1st, 2024.
Yes.
Okay. And do you agree that this is a just and right division of the marital property?
Yes.
Mr. Wilborn has also agreed to be solely responsible for any federal tax liability for 2022 and 2023. And if there is a refund for 2023, the entirety of that refund will be paid to you and credited as for the child support judgment, if there is one.
Yes.
With respect to personal property items, there were a few items that are at the one. Y'all have agreed that you can go pick those up on March 2nd, and those items are outlined in this decree.
Yes.
Okay. And there is also separate property that is being confirmed, and that has been identified in this decree.
Yes.
And you all will sign warranty deeds necessary to effect this division of property.
Yes.
And Mr. Wilborn will sign a deed of trust to secure assumption and a power of attorney to transfer a motor vehicle.
Correct.
Now, although this divorce has been submitted to the court without fault grounds, you are asking for injunctive relief as a result of conduct and behavior of his that precipitated this divorce. Is that correct?
Yes.
And Mr. Wilborn has agreed to that injunction to a certain extent. He has agreed to not communicate with you except for arranging visitation or notifying you of circumstances affecting the best interest of the children or regarding fulfillment of the terms involving payment and property of the decree.
Correct.
He's also agreed not to come near you within 200 feet of you or your premises or employment, except for any purpose, except to exercise visitation granted in this decree, or to attend a planned family event to which invitations to both parties have been extended, or to attend a school activity.
Correct.
And the reason that he might come near your employment is you're currently employed at the school the children are attending. Is that right?
Yes.
Okay. And he's agreed not to engage in any harassing communication or behavior if it's a family event.
Correct.
He's required to give you 24 hours advance notice if he's going to attend a school activity and must stay 10 feet away from you if both are present.
Correct.
Okay. And the final injunction, which is applicable to both of you, is that neither of you will leave the children alone when they're in your possession with anyone under the age of 13 and without having a cell phone with them.
Correct.
And that's for both of you. Now, Ms. Wilborn, I'm going to ask you questions about why you're seeking the injunctive relief. When you filed this divorce, you also sought a protective order. Is that right?
Yes.
Okay. And in fact, back in 2016, Mr. Wilborn had been physically abusive towards you. Is that right?
Yes.
And y'all had separated then.
That's correct.
Did he leave you alone during that separation in 2016?
No, he did not.
Okay. What kinds of things did he do when you separated from him after his abusive behavior in 2016?
He followed me. He continued to harass me on the phone with coming to my house. Promising that he was going to stop the abusive behavior that constituted why we separated.
And would that be combined with behavior that was actually also abusive?
Yes, once we got back together, he was continuing the emotional and verbal abuse.
I'm going to fast forward then to this year. On Mother's Day, that's the date that you separated. Can you tell the court what happened on Mother's Day?
On Mother's Day, Jackson told our sons that he was going to take them to church, and they were distressed because they wanted to spend Mother's Day with me. So I told them that I would take them to my church since we were going to separate churches at the time. And when I told Jackson, he started yelling and telling me how controlling and narcissistic I was and how I was inconsiderate of him. And he continued for a little bit and decided that the boys were going to go to church with him anyway and loaded them up and took them out. And the rest of the day consisted with Jackson telling me that he wanted to separate. It was probably in our best interest that he would separate the businesses, and getting that kind of a plan to telling me that he loved me, he wanted to work it out. I was everything he wanted. I was the best. And so the persona had changed throughout the day, and his communication as well.
And you actually that night left with the children, correct?
The next day, I spent the night with the kids in their rooms, but then the next day I left with the kids.
The next week, did you go back to the homestead property to get some of your belongings?
Yes.
And was there an incident where Mr. Wilborn was verbally abusive to you in front of your daughter?
Yes.
Can you describe what happened?
I went back to get some of my clothes, and he was very, very angry to the point of shaking. And as I walked up the stairs, he just told me how horrible I was, how narcissistic, how this was not fair, this was not right, how biblically it's not right. He just continued how I was a pain in the butt and continued barraging me until I went into the room and he couldn't see me anymore.
And your daughter and a friend were actually there?
Yes, they heard the whole thing.
Was there a time where he made a threat against you or made a threat that scared you a week later
Yes.
at the mobile home?
About a week later, I went back with a friend to get the bunk beds for the kids. At which time he said I could not take them, and he's pulled me aside and told me in a very threatening tone that he would take an axe to the diesel shop and burn down the mobile home which the kids and I were staying in before he would um, lose his family.
Now, we subsequently filed the application for protective order and the divorce. During this time period, were you finding written letters from Mr. Wilborn seeking to reconcile?
Yes, I was bombarded with letters and texts that flipped. One would be trying to scare me that the court would be in our business and controlling us, and CPS was going to get involved, and the next would be how much he worshiped me and how much he loved me, and it just, they were rather lengthy letters and texts.
Now, when we went to temporary orders, we reached an agreement. And at that time, there was not an injunction against how he communicated with you. Is that right?
That's correct.
Okay. Was it a problem for the communications to not be restricted after that?
Yes, because he continued with the barrage of letters and texts.
And at a certain point, did we reach an agreement with his lawyer that you were just going to use the app?
Yes.
For communications? What is the difference between Mr. Wilborn communicating outside of the app and through the app from your perspective?
There's not much difference.
Okay. Why then is it important for you to use the app?
Because my kids use my phone for calling and texting other people, and they have stumbled on some of his texts.
Okay. So does this prevent your children from having access to seeing these communications from Mr. Wilborn?
Yes, because he's the only one on that app, and it's separate from everything else on my phone.
Okay, so they don't have access to that.
That's correct.
Okay. And how does it affect your children when they would see these communications from Mr. Wilborn?
Objection calls for speculation.
From her
Rephrase.
observation, I can rephrase, Judge. Were you able to observe the impact on your children when they saw these communications from your husband?
They were disturbed because of what was said towards me.
And do you think that's in their best interest to be exposed to those communications?
No, I do not.
Okay. All of the provisions that we've made that you and Mr. Wilborn have agreed to in this decree, have you done those to try to minimize the things that your children are exposed to?
Yes.
So, for example, meeting in a neutral place instead of meeting at one residence or another.
Yes.
Okay. And Ms. Wilborn, how does it impact you to get these communications from Mr. Wilborn outside of this controlled app? How does it impact you?
It's unnerving because I don't really want a lot of people to see what's going on and what is, happening. And it's very easy to be on your phone and a message pops up or people can see, or, that kind of a thing. So it's.
And do you need to have your phone on at work?
Yes.
Okay. And so if he communicates through the app, is anybody able to see that at work?
No.
And are you able to then control when you're able to respond to him?
Yes.
Okay. Mr. Wilborn is concerned about according to his attorney, being able to reach you in an emergency. If he has the children and you see a response on the app, are you likely to check it immediately?
Yes, when he has the children, absolutely.
All right, I pass the witness, Your Honor.
Mr. Patante, your witness.
Thank you, Your Honor. I just have a couple of follow-up questions. On your phone, your children's phone, is Mr. Wilburn blocked?
On my phone,
Correct.
yes, because he tried to communicate with me on my phone. That is
Objection,
my
non-responsive.
personal number.
Objection, non-responsive portion. I'm just asking you, I just have that one question. Do you block him? So in other words, he can't call you or he can't text you or other means of communication on your phone?
On my phone, that yes,
All
I
right.
have him blocked.
How about your children? Is he blocked on your children's phone so that he
No,
can't
he is
communicate?
not.
Has he been blocked from your children's phone, say in the last 6 or 8 months at
No,
any time? Okay.
not to my knowledge. My children are, they have their own phone, so I don't know if they have or not. So not to my knowledge.
The app that you have installed on your phone, it's App Close, right?
Yes.
Okay, the app that you have on your phone, App Close, if you receive a message through App Close, do you get some kind of notification?
Yes.
All right. And generally, how quick do you respond to those notifications?
It depends on what's being said and what's being asked.
Have you ever had a situation where he sends you a message on App Close and you don't respond for, say, 2 hours?
Yes.
All right. Have you ever had a situation where you receive a message from him on App Close and you call him in response?
No.
Has he ever sent you a message on App Close and said, please, I need to talk to you. Can you please call me?
No.
Okay. I have nothing further, Your Honor, for this witness.
Malovich,
Nothing further for Ms. Wilborn.
call your next witness.
I call Audrey Diltz.
All right, Ms. Diltz, you've been called as a witness at this time. You are still under oath. Did you follow all of my instructions in the time that you were in the waiting room?
Yes.
Did you speak with anyone else about the testimony being given in the case?
No.
And did you listen in any way to our stream or our hearing here today?
No.
Would you tell me your full legal name, please?
Audrey Lee Diltz.
Ms. Malovich, your witness.
Ms. Diltz, can you tell the court, you live here in Alpine?
Yes, I do.
How long have you known Lee and Jackson Wilborn?
For 15 years.
Okay, and what's your relationship with them?
I've been friends with Lee and Jackson for a very long time. I also worked for them for 9 months.
Okay. And in more recent years, have you become a confidant of Lee Wilborn?
Yes, I have.
Okay, and in that role, has she confided in you to some extent about issues in her marriage?
Yes, she has.
Okay, and I'm not going to ask you about the substance of those communications. I'm going to be focusing on my questions on your own observations, okay? All right. Have you had the opportunity to see when Lee has received text messages or has talked to Jackson within the last year?
Yes, I have.
And I'll focus primarily on before she moved to El Paso in those few months this summer. Can you tell me what you observe in terms of Lee's demeanor after Jackson has either sent her a text or called her or talked to her in any way?
She typically gets very very tense, but she tries to hold it together in public. She would never let anybody else know, not her children, not my children, know how that she'd been affected at all. But then, so what I would see is I'd see her jaw set and like her shoulders kind of squared like someone does when they're trying to hold it together. Or if it wasn't that response, then she would begin to look like a shell of herself. Lee by nature is very vibrant and she laughs easily. And sometimes when we were at the park, she'd even make sure that she kept on sunglasses, even on a cloudy day, because she didn't want anybody to see that she was upset or crying. And she kept that demeanor until my children were away, until her children were away, until there was nobody around that could see her lose it. And then she might cry a little bit, but clearly upset and clearly still trying to keep her composure. And I've never seen Lee like that otherwise.
So you actually see physiological reactions to Jackson's
Yes.
communications with her.
Yes.
And to be clear, this is not you seeing him like physically abuse, or this is just
Never.
seeing communications.
Yes.
Okay. Have you ever actually seen a text message exchange that she's had with Mr. Wilborn?
Yes.
Okay.
One time.
Okay. And when you saw that, were you able, in your own view, to understand why it would have an impact on her?
Yes, I was.
Objection calls for speculation.
Overruled. You can answer.
What was the nature of the text messages that you thought were something that could provoke that kind of reaction?
Well, the text message would start out kind of nice. I mean, very normal exchange from a husband to his wife, like, hey, I need to talk to you. Can we talk? And then it would get more, why aren't you answering me? Why aren't you talking to me? And then the nature of it would seem angry. And that would, if my own husband had spoken to me that way, I would be like, what's your problem? And anyway, the one time that I saw that exchange of text messages, they were in a flood. It wasn't like, you know, here's one and let's wait for a while. It was like, here's another and here's another. And yeah, that was, I very much understand why that bothered her. And I told her so. So.
In your opinion, from your knowledge of Lee and Mr. Wilborn, do you think Lee would ever do anything to harm her children, their best interest?
Never, not in a million years.
Do you have any knowledge of her trying to restrict access to her children, from her children to Mr. Wilborn as a way of hurting Mr. Wilborn?
No, I've actually heard her say the very opposite, that she's told me that she's told the kids that they could call him and talk to him anytime they would like to. And she's even offered that while we've been meeting at the park before, where she said, well, if you want to call Pops, you can talk to him right now, with no, the same tone that I would use with my own kids, no hesitation.
You're aware that there is a dispute between the parties, and you're not aware of like all of the terms of this divorce, correct?
No, I'm not.
Okay. But you are aware that she is seeking to have his communications restricted to using
Yes,
an app. Okay.
Yes,
You are also the mother of 5 children, correct?
yes.
Do you think it is in the best interest of Ms. Wilborn and these children for his communications to be restricted?
Objection calls for legal conclusion. Oh, I can't hear you, Judge. I'm sorry.
I don't know how that happened. I haven't touched anything. Ms. Palovich, do you want to respond to his objection?
She can give a lay witness can give an opinion, Your Honor. This is a bench trial. The court can give it whatever deference.
Whether she thinks it's in their children's best interest?
As a
The
mother of
question?
5, and as knowledge of seeing these communications and her knowledge of the family, does she think it's in their best interest? It's just a lay person's observation.
I'll allow it, but I'll give it the appropriate weight and credibility, if any, there is. Go ahead and answer the question.
Ms. Dilts, what do you have an opinion on that?
Yes, I do. I'm also friends with 3 of their children and their oldest children. And I would say absolutely that it's in Lee's best interest and the children's interest.
And why is that?
Because as a mom, if you are regularly having your ability to just be a mom, to be in the moment, to take care of things and handle things, and someone is texting you that you just need a sec before you can deal with that. I would absolutely want someone to be able to put a hold on that for me and allow me to gather myself, compose myself, and deal with something that has broken my heart when I'm ready.
Thank you, Ms. Dilts. I pass the witness.
Mr. Patante, your witness.
Thank you, Judge. I just have a couple of quick questions. Ms. Dilch, you testified that you were a confidant of Ms. Wilburn, and you have been in the past. Have you ever had an opportunity to speak with Jackson privately about what's going on in the divorce and the raising of the children?
I have not asked him about that because Lee and I have been closest friends for years, so.
Has he ever reached out to you?
No.
Okay. And have you ever reached out to him to discuss his version of what you have testified to here today?
No, I have not.
All right. You mentioned that you had seen one text or one series of texts on a particular date. What was the general topic that they were discussing?
That I don't remember. I remember that he wanted to talk to her. I remember how it affected her. And I remember that the text came in a flood. And I remember my own reaction that the only reason she showed me is that she was wondering if she was misjudging it. And she wanted to give him the best view possible. And I told her, no, you're not losing your mind. You're not crazy. That would drive me insane.
And you were reading, was she showing you her phone or her iPad or whatever it was that the text messages that were coming in on?
Her phone. And it was at the park. I could even show you the bench where we sat.
I'm sorry, you can show the bench where we sat at? Is that what you said?
Yes, sir. Like,
okay.
That is the nature of my memory.
Got it. But she showed you the phone. You kind of scrolled through and you were reading some of the messages. Is that what your testimony is?
Yes, sir.
But you don't remember what they were actually talking about, what the topic was or the subject?
Not in detail. It was his wish to talk to her, and that is what I remember.
And do you remember, was he asking her to call him or to talk to him?
Yes.
And was she responding to him?
Spoken.
Was she responding to him?
Spoken.
Sorry, Ms.
sorry.
Court Report. We're talking over each other, sorry. My question is, and what I'm trying to get to is, you said he was sending multiple texts. I'm guessing you were saying he was sending multiple texts and she wasn't responding. Is that correct?
She had already responded and he would not let up.
Okay. Do you recall any of those texts saying, hey, we need to talk, can you please call me, or anything of that nature?
I don't remember clearly, no, sir.
All right. And you don't remember the general topic, like they were talking about one of the children being sick or a school issue or anything like that? You don't remember what it was?
Well,
okay.
I know it wasn't sick or anything that had to be answered right now.
But you don't remember what
I do remember.
Okay.
No.
I have nothing further for this witness, Your Honor.
Ms. Malovich, any follow-up?
No, Your Honor.
Is this witness released?
Yes, from our perspective, yes.
Yes, Your Honor.
All right. Ms. Dilts, I'm going to release you. You will not be recalled to testify. I'm going to put you back out of the room. You can go about your business as you wish. Thank you for joining us. Ms. Malovich, call your next witness.
I call Jackson Wilburn.
All right, Mr. Wilburn. Let me move you up into the seat here. All right. You are still under oath, sir. Tell me your full legal name.
Jackson Wilburn, Jackson Curtis Wilburn.
All right. You may treat this as a hostile witness, Ms. Malovich, in your questioning. You may proceed.
Mr. Wilborn, were listening as I went over the divorce decree with Ms. Wilborn. Would you agree with me that that reflects the entire agreement of the parties?
Yes.
With the exception of
Yes.
the app close.
Yes.
Okay. There are some real estate documents that need to be signed as part of the closing. Will you be able to have those executed
Yes, I will.
by the end of January?
All right. Hang on one second, Mr. Wilburn. I need you to be patient, even if you know where the question is going. I need you to let her finish until you hear the question mark hanging in the air and then answer. Okay, sir?
No problem. Go ahead.
Ms. Balovich, ask that question again because I didn't get both voices.
Sure. I forwarded these documents to your attorney. If they get back to you this week, will you be able to have those executed within the next week or so?
The documents that you were forwarded to, now that question I need you to repeat. Go ahead.
Sure. I've sent some closing documents to your attorney.
Okay. As of when?
Assuming they get those to you this morning.
Okay.
Assuming they get
those. I did not get those yet.
Assuming they get those to you within the next week, will you be able to come in and sign those?
Yeah, where am I coming?
Before a notary public to have them signed.
Yeah, that should be fine.
Thank you, John. Mr. Wilburn, what is your objection to using the app close?
I don't have an objection to using app close. If that's what the suggestion is being made, then the objection was not heard. I have an objection to that being the only source of communication. That is not okay. We have I want to read to you right here in our documents that we're supposed to follow. Number 2 on page 3, it says I have the right to confer with the other parent to the extent possible before making a decision concerning health, education, and the welfare of the children. That's really not something that's going to happen on a texting app. And if I'm being blocked from all other forms of communication, all of them except a texting app, I got a problem with that. Because there's some things that we're going to actually need to discuss. Scrolling down on that same page in number 3, it is ordered at all times Lee Wilburn and Jackson Wilburn as joint managing conservators. By the way, that's the operative word here. Joint managing conservators shall each have the following duties: the duty to inform the other conservators of the children in a timely manner of significant information concerning health, education, and the welfare of the children. That's something that's not going to happen on a text. Most texts are 2 to 3 sentences. Texting was not meant for lengthy discussion. There's some things that we're just going to have discussions about. And being limited and being told that I can't discuss something with Lee, pick up the phone and call her and say, okay, well, let's just talk about this, is akin to somebody in the 90s being told at the time the technology of the day was fax. Somebody said divorcing in 95 and a judge saying, well, you can only communicate by fax. Wait a second, I need some help here. You know, it's very limiting. Text is very clumsy. We all send texts that come out wrong because you're trying to limit a large amount of information into 1 or 2 sentences. And it's just very, this is not how I communicate. Okay. I don't mind using the app. I mind that being my only source of communicating with Lee. And that's just not appropriate when I am a joint parent. We're called, a joint conservator parent. That's just not appropriate.
So since the app was ordered for your communications last summer, have there been any occasions that you've not used the app to communicate with her?
Absolutely.
And what were those?
Those were times when I needed to actually pen down a letter for Lee and pen down my thoughts of what was going on and something that was not going to be happening on an app. And I did a very good job of penning those letters, if I do say so myself. They were very nice, and none of them were offensive, the letters that I wrote to her. And I would appreciate if those letters be read. I want to know what's offensive about them.
So in addition to, you were restricted to use the app close, and so you wrote her some letters
Sure did.
on paper.
Sure did. Mhm.
And you believe that those were very nice and non-harassing.
Yes, I do.
Okay.
I have those right here. I have copies of them. I would like to read them if you'd like. If we
And
have,
then any other communications that you have made to her not using the app.
and any other communications not using the app, yes, they were. My court orders were harassing, vulgarity, making threats. Harassment is. I'm finding that this is very subjective. What Lee's claiming to be harassment is he talked to me. I even heard that I couldn't wave at her. I waved when I was going by at McDonald's, and then I found out the next week I was being challenged for waving. So apparently, it's really subjective. What Lee's calling a harassment.
My specific question, Mr. Wilborn, is have there been any occasions since we entered a Rule 11 agreement that you would only use the app, other than the written letters that you wrote her, where you've had to communicate with her in another way?
Has there been any other? Yes, I did. I talked to her on my children's phone. The kids were talking to her, and I asked me, I talked to your mother real quick because we were trying to make some plans concerning I believe it was a trade-off agreement, but it was again something that we needed a little bit of discussion on. And I did discuss that with Lee, and that occurred 3 weeks ago.
Okay.
And I don't believe any of that was harassing. I don't. It was a nice conversation. It was just a conversation about when and where, and if somebody could do something. I really don't remember what it was, but it was if this child could do this, and I was fine with it. I have requested in the past to communicate with Lee concerning the children's excessive use of cell phone use, and I tried to include her in the conversation. And she objected. She didn't want to be included in the conversation about the kids' use of cell phones and excessive use of playing on their cell phones. And those are things that we needed to talk about as mature adult parents. And for some reason, she took offense to that. I said, what's going on here? Why are we not able to talk? Again, this is the same problem that sounds and resonates a lot with what you heard from Audrey Dills. You don't know what was the background problem and why I keep getting cut off in communication when I'm trying to solve a problem. And you don't, neither did Audrey.
Please let me see if I can summarize your position and tell me if I have this wrong. You would like to be able to write her letters.
Absolutely.
You would like to be able to talk with her on the phone about issues that you think are concerning anything.
Well, yeah, if I'm at the store and say, hey, honey, I'm trying to text her, hey, we sale on jeans. I know the school opening's coming up. Sale on boots. What size? I'm going to need to call her because as I'm going down the aisle, I say, well, they don't have that size, but they do have this. I have this and that. I can't do that back and forth, waiting 20 minutes, 30 minutes, which is the average for Lee to respond on a text. To get the kids something that they need. This is, we're talking about the next 13 years, and we're thinking that we're going to do all our communication by text. We're talking something that's just 2 steps up from smoke signals and Morse code.
So you would like for her to be able to, she needs to respond immediately to your text. Is that
Not
what I
immediately,
understand?
but well, it's not just about a reasonable amount of time. I understand that Lee has things to do, but if she's in her car and she's driving around, she cannot be texting, but she can hit that little button right there on Bluetooth and continue to talk to me. And I'm at the store and I can say, well, honey, I'm picking up some jeans for the kids and they've got school clothes. I do that for my children because I care.
And so you want her to answer the phone in the car when you call?
Absolutely. That's what Bluetooth is for. We can talk and I can help her out. And that's been my whole crux since the very beginning. And you even find that in those letters that I'm being told I was harassing her about. I would like those read out loud.
And are there any emergencies that have occurred in the last 4 or 5 months since you've been required to use the app?
Nope.
Yeah.
Nope.
Okay.
Nope. That doesn't predict the future.
I pass the witness.
Mr. Patanti?
Thank you, Judge. Mr. Wilburn, has there been occasion where you send an app close message and you don't receive an immediate response? An immediate I'll define as 5 minutes or less.
Oh, yes. Frequently.
All right. And when you say frequently, how often?
I'd say most of the time, most texts that I send to Lee probably has a turnaround time of about half an hour to an hour.
Okay. Um, I,
Sometimes we're talking as much as a day.
all right. And you've stated, and a lot of the questions that Ms. Malovich was asking you, I was going to ask you on direct, so I'll just ask you during my cross-examination of you during this. Your issue, what's your issue and succinctly, what is your issue and your problem with the app being the sole mode of communication? Does it have to do with issues that regarding convenience, such as you described, the clothing example,
Just an example. Just an example.
health, welfare, and safety, things that you want to discuss
If
with her?
something happens, yes, exactly. If something happens, and to me, we're in a car accident, that happens, okay? And I have to hand my phone to medical personnel and say, here's my wife's number. That number had better not be blocked. And I say, please call her, get some help. I can't breathe. I'm crushed right now. That phone had better work. And
Are
that's
you
just another thing that I'm concerned about with all the blocking that's going on, is that, I love my children, and I still love Lee. I really do. And I'm concerned about not being able to communicate and get messages through, or having my hands tied behind my back and put in a box where you can't communicate. Again, 90s facsimile. That's the only way, really.
And you've agreed to not communicate with Miss Wilburn on issues other than the children and your property division once that's finalized. Is that correct?
That's correct.
All right. So you're not going to call her randomly or text her randomly, hey, let's
her.
go out for a date, or hey, do you want to do
No.
X, Y, and Z? Or it's just nothing between you and her, just between the children.
There are some things between her and I that obviously we were married for 28 years. Let's be realistic here. There are some things that are going to be said, but generally speaking, we're talking about the welfare of the children here, and again, having access closed off is not safe. It's not intelligent. It's not. Again, texting is a very clumsy way to communicate, and be reduced to texting as my source of communication. I got a problem with that.
The letters that you just referred to that you'd like to read into the court, I would ask, do you have those as a digital copy that you could upload? Or I'm not sure the process, Judge, on
No, I don't.
because I don't have a copy of those.
No,
How long are these letters? Meaning, are they?
one right now? I've got one here that's just 2 pages here. I was sent on Sunday, July 9th. I know that
Mr. Wilburn, stop right
Hold
there.
on.
Go ahead.
You don't get to just read stuff into the record. Listen to your questions. Go ahead, Mr. Bertanti.
This letter, you said you were sent. Did you send this, or did someone send this to
her.
you?
This was actually, I told her that I had a letter. I didn't.
Hold on. Hold on 1 second. Put the letter down just for a second. So the letter, this was a written letter that you sent to Mrs. Wilburn?
I actually called her and let her know I had a letter for her outside in my mailbox, and she drove by and picked it up from my mailbox.
Okay.
She by and got the letter on her own will and volition.
Okay. And what was the general topic of that letter, or topics?
Well, this particular letter was about the exchanging of the children, and it was conflict resolution and things that we could do to maybe come up with a better option for us exchanging the things that she wanted from the house. And it was something I came up with a resolution, and I asked her. I pinned it out very nicely, and I asked her if she would like to do that. And
okay, let me ask you a question. Over the last, let's say 6 months, let's say since June, how many letters have you written to her?
Let's see, 5.
5. Okay.
It's June. Yeah, 5 letters.
And what's the difference between? I'm not familiar with AppClose. I know I've used Our Family Wizard in the past, but that's another app. But in AppClose, what's the difference between you writing her a letter and putting that in an AppClose message, I guess?
Because AppClose is only this long. At some point, you're taking way longer to try to text.
Is there a limit? I guess you'd call it a character limit, meaning you only get to use.
If there is, I haven't reached it, but I don't want to try.
Okay,
It's an app.
okay.
Uh, yeah, go
How do
ahead.
you, hold on. How do you access the app? Do you use a laptop, an iPad kind of thing,
No,
or,
it's on my phone. All
all
right.
right.
You just
Do you, hold on. Do you have, uh, is that your only method of accessing the app is through your phone?
yes. Mhm.
All right, so you're typing into your phone on your phone's small
Right.
keyboard.
Yeah.
Okay.
Lose the phone. I lose the phone. I lose contact.
All right, so this letter that you just held up a little while ago sounds like a lot of information. How many pages was that letter?
That particular letter was two
Two
pages.
pages.
Two
So what you're
pages.
saying is,
We're talking 400 words.
okay, so what you're saying, or what I think you're saying is it was easier to send the letter for you. It was easier to write the letter and hand it off to her than it was to type this up on the app.
Absolutely.
Do you think was that information important enough to you that that information could have been sent by the letter or the app or what have you, plus a conversation, like an actual verbal oral conversation with her?
It could have, but it couldn't. In other words, somebody there, you get the he said, she said, maybe. I don't
Okay.
mind having a verbal conversation, but in something like this that was dealing with the exchange of goods from the house, I wanted it all recorded and and I had a copy.
And the court is aware of this, but none of these letters that Miss Wilburn has claimed you have been harassing her with have been introduced into evidence here today. Is that correct?
You're asking me? No, I don't know.
Yes. Okay. All right.
I don't think so. No.
I have nothing further for this witness, Your Honor.
Ms. Balovich?
Nothing, Your Honor.
All right. Ms. Balovich, call your next witness.
Tony Helms.
Ms. Helms, you have been summoned to testify. I want to verify that you have followed all of my instructions. Did you follow all of my instructions?
Yes.
Did you communicate with anyone about the testimony being given here in the courtroom?
No, sir.
And did you watch or listen to any part of the hearing since I excused you after placing you under the rule?
No, sir.
Would you tell me your full legal name, please?
Tony Ellen Helms.
Ms. Balovich, your witness.
Ms. Helms, where are you testifying from today?
I live in Bandera, Texas.
Did you used to live in Alpine?
Yes.
And how do you know Jackson and Lee Wilborn?
I used to work for them. My husband and I did, and we met them first through Grace Christian Fellowship.
And how long
then
have
we
you
worked for
and how long have you known them?
them since 2007, I believe.
And how would you characterize your relationship with Jackson and Lee?
My husband and I both had worked for them, and we had fellowship together. We called each other family for years, and they've been very close friends for years. We don't always get to communicate much since we moved back to the Hill Country in 2013, but I can pick up the phone at any time and talk to Lee, and there's been times when I could do the same with Kurt.
Okay. And I've asked you to testify today on behalf of Lee, but just to be clear, what is your feelings toward Mr. Wilborn?
He is like a brother to me, and Lee is like a sister to me.
Okay, so you care about them. You care about them both very much.
Very much, yes.
Ms. Helms, when I first called you, you told me you were not surprised that the Wilborns were getting divorced. And is there any specific behaviors about that Mr. Wilborn has exhibited that you think were the basis for that opinion?
Can I
Just
ask you to
over the-
focus in on the remaining issue in the hearing? That was a very broad question.
Yeah.
I don't want to open that.
Sure. Has Mr. Wilburn ever engaged in communications with Ms. Wilburn that you think could be viewed as harassing by her objectively?
Objection, speculation, I would ask to be limited to that she's aware of.
That she's aware of?
Okay, sorry.
I think
Thanks.
the question was that you believe she could objectively find harassing. I think that's actually a subjective objective crossover. If it was an objective question, there's no objection. If it's subjective of what she thinks she might think, then it calls for speculation. So would you clarify and restate your question for me?
Are you aware of communications from Mr. Wilburn toward Ms. Wilburn that appear to be harassing?
Yes, how that gets defined as harassing, guess that's up for speculation. But for answering your question, I would say yes.
And can you describe it?
Just over the years, seeing communications with each of them, of how I would say the word manipulation is what comes to mind, and times that. So why? Because I'm trying to put this into words. When in the times that I've known them, conversations with each of them having Lee's behavior, according to Kurt, was not what he thought it should be. So I guess I could say, like, his attempts at behavior modification through different means, and just correcting as if she were one of his children, and using words to try to get that behavior back into a way that he was pleased with, and saying very hurtful things. And I've sat across the table a lot with Lee, having coffee there in Alpine years ago, and times that we've gotten to visit since then. Yes, there have been some great conversations where they've come and we've seen them here in the Hill Country, where we've met up for meals, and things seem to be going well. And then there'd be months go by and that would not be the case, where Lee was in tears again. And it's just been a pattern since I've known them.
So Ms. Helms, I want to go back to what you specifically said before. You used the word manipulation and you used the term behavior modification. Do I understand you correctly that Mr. Wilburn would try to use his communications with Lee, believed his communications could change her behavior? Do I have that correct?
Yes.
Okay. So he's talking to her and he's trying to instruct her how to behave. Is that what you observed?
That's what I've observed.
Okay. And has he talked to you about that? Does he see anything wrong with it?
We've had some conversations, and like I said, because I've always felt like they were a brother and a sister. And so when he would call and would want counsel, and happy to help, not professional counselor, but just as a friend, as a brother-sister relationship. And when he would tell me the things that he didn't like that Lee was doing, how she wasn't doing her job as a mom, the way he thought. And so he would, I don't remember specific details so much but he was telling me the way that he was trying to get her to correct her behavior. And I would say, you can't talk to her like that. You can't treat her like that. She's your wife. She's not an employee. She's not your children. She is your wife. She is your partner. She's your equal. And you're going to, at one point, I remember telling him, you're going to have to back up and start completely over, because what you've done is, it's berating, and it's been, in my opinion, it's been verbally abusive.
Ms. Helms, did Mr. Wiltborn ever exhibit insight that what he believed that these communications were harmful?
He didn't ever think it was harmful. He thought that was the way it should be done.
Okay. And did he vacillate between the berating behavior and nicer communications?
Mm-hmm. Yes. Times of trying to correct her behavior through just correction and coercion. And then he would, flowers and roses, and take her on vacations, and and what husband wouldn't do that for his wife? But in the meantime, there would be all this verbal attacking of her character.
And did you see
her desire, the desires of her heart to be a wife and mother?
And did you see the impact that this had on Lee, these communications?
I did.
And what was that impact?
Saw a woman being broken down year after year. And till she finally just gave up.
I pass the witness.
Mr. Petante.
Thank you, Judge. You had mentioned that the communications were changed somewhat between 2013 and today because you moved away. Is that what you said? And you moved away in 2013?
That's correct.
All right. And so, I'm sorry, can the court hear that? Somebody's sending me a text messages. Is that coming through on the It's not. Okay, good. Sorry about that. I want to first ask you about conversations, say in the last year and a half. Have you been privy to any conversations between Jackson and Lee? Like you were listening in, or you were with them at the time they were having a conversation?
Not in the last year and a half.
All right. And so
it's been a few years.
So your experience in terms of verbal oral conversations is solely what Lee is telling you?
Well, no, I had conversations in years prior to that with Lee. I mean, with Kurt on the phone, and when he would call me up and ask me how to help get this thing straightened out,
So
how to help him. Can I get through to Lee? Can I help him correct Lee's behavior?
Okay, sorry, I didn't mean to interrupt you. So your perception or your understanding of their conversations is through you conversing with Lee and you conversing with Jackson, not them together.
At times we've had conversations in the past, not in the last year and a half, but prior to that, I've had conversations with them both.
All right, well, let's address that. When's the last time you had a conversation where it was you were a party to interactions or conversations between the two of them? How far back is the last time?
It's been a couple of years since they came down with some of the kids we had a meal in Fredericksburg. And then prior to that, there was times that it was a New Year's that they all came down with and they had just gotten Kurt's mom, Anne, and they all came and stayed with us for a few days at our home in Gillespie County outside of Fredericksburg.
All right, let's talk about, give me a general sense of when that was that you said the last time in Fredericksburg. Are we talking 2-3 years ago or more than that?
I think it was we've been here in Bandera for a year and a half. So I would say it was 2.5-3 years. We were sitting the back part of the the brewery in Fredericksburg. We sat in the back and all had a meal together, and they had some of the kids with them.
Okay. Have you ever seen, either through her sharing with you on some other electronic medium, or she's standing right next to you, have you ever seen text messages between her and Jackson?
She's had, I believe she sent some to me. We've talked
When-
about them.
When did she send them to you? And my follow-up question is, when did she send them to you, and when were the text messages? When was that text message interchange?
I believe that has been within the last year, and their interchange was within a short time frame when she shared them with me.
Okay, and was there anything in those that concerned you, the text messages between Lee and Jackson?
Yes.
Okay, what was the thing that concerned you?
There would be things of, he's expressing his love for her and trying to work this out. And then at other times sharing that, or him saying that he was how can you do this to me?
Hold on one second. Hold on one second. Are you reading something right now?
No, I'm not. I'm
Okay.
just trying.
You're going from memory. Okay, I just want to make sure.
Going from memory. Yes, sir. I don't have them right here in front of me now.
Go
But
ahead and finish your answer, Ms. Helms.
so just facilitating back and forth from how much I love you, why are you tearing our family apart? This kind of
Okay.
so accusations and
Have you ever seen or reviewed any letters written by Mr. Wilburn to Miss Wilburn?
not letters specifically.
All right. Aside from text messages and then these verbal conversations, any other medium that you've seen communications between the two?
No. But text messages. That's all.
I have nothing further for this witness, Your Honor.
Ms. Balovich,
I have nothing further.
is she excused?
We do not plan to recall her.
Yes, Your Honor.
All right. Ms. Helms, you're through testifying. Thank you for joining us today. I'm going to move you out of the Zoom room and you are free to go about your business. Thank you, ma'am.
Thank you.
Ms. Balovich, call your next witness.
Petitioner rests.
Mr. Patanti.
I think we've covered it in my cross of Mr. Wilburn. I think, I was going to call him as a witness, but I was able to do my cross and get all the information that we need. So I'm fine. We have nothing further.
So
you rest?
Yes.
All right. Both sides close?
Yes, Your Honor.
Yes, Your Honor.
All right, Ms. Balovich, brief closing argument.
Your Honor, I'm just going to focus, of course, on the issue that the court needs to decide that was not agreed to. You heard my client's testimony. She wants this communications restricted by Mr. Wilburn for the benefit of the children, primarily, so they not be exposed to these communications. You heard evidence that he has been verbally abusive to her in the past before this divorce was filed in a very violent way. He hasn't rebutted or disputed that evidence. You heard from Audrey Diltz that as recently after the separation, that she would observe the impact of communications and how it would affect Ms. Wilburn, that she would have to shore her up herself physically, to not expose children to how she was feeling. And it wasn't until they left that she would break down and cry. These are communications before the app was used. She actually got to see the communications that Ms. Wilburn asked for clarification. Am I crazy to have this reaction? And you heard Ms. Dilt's testimony. No, you're not crazy. If my husband spoke like that to me, I would want to know what was wrong. What was the nature of those communications? They sounded innocuous. They started from, something very nice to, why aren't you calling me? Why aren't you responding? And they came in a flood of messages. You heard her opinion, which the court can give whatever deference that it wants, that a person who is similar to Ms. Wilburn, a person who is a mother, of 5 children, who's getting things like that, and you heard the impact that Ms. Dilt said it would have on her, would need her composure to have time to respond. It's a very rational response. Then you heard from Mr. Wilborn himself. Notwithstanding the opening statement that his attorney made, that this was for the nature of emergencies, Mr. Wilborn made it clear that if not restricted to the app, he's going to use the communications anytime he wants. He wants to be able to write her letters. His attorney said, but this would be about, the children. And he said, no, we've been married for 28 years. We have a lot to talk about. He described to you the letters that he wrote her. They weren't just about the children. They were about conflict resolution. They were about how he loves her. He says they need to have discussions, but she needs to respond immediately. She needs to talk when she's on the phone in her car. Mr. Wilborn has made it very clear that if this communication is not restricted, he's going to drive a truck through that exception, and he's going to contact her whenever he wants for whatever purpose, and he expects her to be on demand. And Ms. Hellam's testimony was introduced to show you this is not a new thing. This has gone back to 2016. This is a person who sought counseling for his behavior with his wife and asked, how can I improve? He got this feedback, and he's continuing to do it. Back when they were getting counseling before, Ms. Helms described him as berating. She said the communications would vacillate and that he would use his communications for the purpose of behavior modification and to correct her, i.e. to treat her like an animal. This divorce decree by agreement reflects a good faith effort on the parties to go forward and do what's best in the best interest of their children to end a 28-year marriage amicably. And it's to everybody's credit that they did receive this agreement, that they did reach this agreement. But Ms. Wilborn and Mr. Wilborn have introduced testimony that shows Mr. Wilborn's communications must be restricted. An app will put a control on him so that he cannot use verbal communications or written communications for purposes not allowed in the injunctive relief. It will create a record in the event that contempt needs to be requested, which is the only relief for an injunction. And so we ask the court to grant the restriction in the injunctive relief that his communications be limited to the app.
Thank you, Mr. Patante. Your closing?
Thank you, Judge. I'll be brief. I think the evidence shows and doesn't show. Ms. Wilburn has testified to harassing communications in writing, yet she did not produce any exhibits to show the court what her interpretation of harassing was. Mr. Wilburn has testified that he needs to contact her on occasions when an app is not going to be a functional or an appropriate way to communicate with his ex-wife or soon-to-be ex-wife. We're asking the court not to limit his communications, his sole communications, to an app when there's other conversations that need to be had. And in terms of an emergency or the health, safety, and welfare of the children, it's appropriate that Mr. Wilburn, if he sends a response, if he sends a communication via the app close app, that if Miss Wilburn is to respond, that she responds within a reasonable time. And if she doesn't respond within a reasonable time, then Mr. Wilburn should have the opportunity to text or call Miss Wilburn, ask her a question about, has she received the information or has she received the communication, and will she respond? And if appropriate, sometimes a conversation needs to take place, as Mr. Wilburn has testified. You can't have conversations via text for the next, like he said, 13 years on every issue that needs to be discussed when it comes to children and their health, safety, and welfare. So we're asking the court to not limit his communications to the app close app and allow him the flexibility, however the court deems proper, to, in cases of emergencies or things that need an immediate response or a response within a reasonable time, that he be able to either call her or text her just for that reason. And so we're asking the court to provide some level of opportunity for him to do that.
Thank you, sir. Ms. Valovich, you are the petitioner. You get the final word if you wish.
And I'll be brief, Judge. I'm not going to repeat my arguments other than you heard Ms. Wilburn's testimony. When she hasn't responded, it's been, a couple of hours, which is not inappropriate. His demands are immediate. He wants it within 30 minutes. And again, you heard the testimony of two individuals who have no dog in this, who said they've seen the nature of those communications and his demand of what an emergency is not reasonable. You've heard no testimony that my client has done anything to harm these children or would not respond if it was something important. And so his request is not warranted.
All right, thank you both. I am prepared to rule on that issue. The court finds it as venue and jurisdiction in this case. I find there is no reasonable expectation of reconciliation, and so I hereby grant the divorce. I find there are 5 children subject to the jurisdiction of the court. I find that the provisions as to conservatorship, possession, access, support, and insurance for the children are in the best interest of the children. I will approve and adopt the agreement of the parties as the order of the court. With respect to the division of the marital estate, I find that the proposed division as laid out in the agreed decree is a just and right division. And so I will approve the agreement and adopt that as the order of the court. With respect to the contested issue on app close, a few things I want to mention. Number one, although the record does not so reflect, I have paid close attention to the demeanor of everyone in the room, and I have taken that into consideration on these issues. There is clearly, although I understand you have been using this app to some extent under the temporary orders, a complete absence of understanding of the features of the app. The app has audio calling, just like a phone app. There's no difference. The app has document exchange. So if there was a written letter that someone felt was related to the children, it could be sent through the app. The app is a communications app. It has a calendar. It has documents. It has all of these things. The one thing it has is it has automatic recording. And it does create a record for the court. So the argument of I want to be able to make an audio call, if that's not barred by something else in the agreement or the injunction, that happens. Lower your hand. That happens in the app. All of those things are possible in the app. So I am going to order that the parties use app close based on the evidence that I've heard. The parties are now divorced. I have rendered that decision. I want to add one more thing. There is no requirement that a former spouse must jump to and immediately answer anything. And I think the wording was something needs immediate response or respond within a reasonable time, 20 minutes, 5 minutes, 30 minutes. Mm-hmm. There is absolutely not going to be any order for any ex-spouse that they are required to respond in any time or in any way to an outreach. I was concerned by the statement that she might continue to be an emergency contact after divorce as the parties move forward. It's clear to me that communications need to be restricted so that it more accurately reflects the former spousal relationship, not the strained spousal relationship that has been in place over the years. I note that in the agreement and the injunction that has been entered, which I am approving and entering today, there is a prohibition by agreement, an injunction against Mr. Wilborn communicating in any way with Ms. Wilborn, except for arranging visitation or notifying her of circumstances affecting the best interest of the children, or communicating regarding the fulfillment of the terms involving payments and property. That agreed restraint, which is now in effect, eliminates much of these types of communications that I've heard need to take place going forward. So I expect the parties to comply with their agreement, with the injunction, and with the court's ruling. With that addition, I will note that I have fixed my initials next to the yes line on page 20. And with that, I am placing my signature on the document, finalizing the divorce, and e-filing it today. Ms. Balovich, do you have any questions about my ruling?
I do not, Your Honor.
Mr. Patanti?
No, Your Honor.
All right. Thank you, everyone. I want to wish you the very best of luck going forward. No, Mr. Wilburn, this is not a time for the parties to respond to the court. You may communicate with your lawyer, and if there's something that needs to be brought to my attention, they will do that in the appropriate and formal manner. Thank you, everyone. We are off the record. We are adjourned. You are
Thank you.
excused.
Thank you, Judge.
Thank you, Your Honor.